Good morning. This is a briefing for the House Judiciary Committee. We're going to be hearing regarding the work from the Attorney General's office related to the medical examiner and their mischaracterization of deaths that occurred as a result of police actions. We're going to hear from the Attorney General and from others in the Attorney General's office, and then take questions. I hope that we'll be done in no more than an hour, but this is a challenging issue, an issue that I expect that we'll have some questions. So it may go a little bit over that, but we'll try and keep it as close to an hour as we can. With that, I'm going to hand it over to the Attorney General, Anthony Brown, and we will bring up his PowerPoint presentation.
And Mr. Chairman, the PowerPoint will be for Dr. Kukaka.
Okay.
So if that's fine, I'll begin, and then you can tee that up for Dr. Kukaka. Excellent.
Yeah, thank you.
Well, thank you, Mr. Chairman. It was great seeing you a few weeks ago in Ocean City for the Maryland State Bar Association conference. I thank the members of the committee for inviting us as well, and for your work. I know, it's not just the 90 days of the legislative session, but for 12 months, you continue to do the work in Annapolis, in the community. So for that, I thank you. And I do appreciate this opportunity to brief you on our OCME audit findings. And I'll use OCME, that's the Office of Chief Medical Examiner. This audit began after serious concerns emerged from the Derek Chauvin trial. You'll remember Derek Chauvin was prosecuted and convicted of murdering George Floyd. Maryland's former chief medical examiner, Dr. David Fowler, he testified as a defense witness. He claimed, among other things, that George Floyd died from sudden cardiac arrest, not asphyxia. Dr. Fowler attributed Floyd's death to heart disease, drug use, and carbon monoxide. He argued Floyd's death should be classified as undetermined, not homicide. Everyone on this call here, on this Zoom, saw the video recordings of that event and were shocked by Dr. Fowler's conclusions, and over 450 medical professionals immediately challenged those conclusions. They wrote that this carbon monoxide theory was baseless and showed obvious bias. The doctors stated their disagreement was a matter of ethics, not opinion. And this unprecedented medical outcry prompted former Governor Hogan and my predecessor, Brian Frosch, to initiate this comprehensive audit. So the audit, which is an independent audit design team, included forensic pathologists and social scientists. We began by examining over 13,000 deaths during Dr. Fowler's tenure from 2003 to 2019. Each case involved someone who died in law enforcement custody. Between September of 22 and March of 24, we narrowed our focus significantly, and we identified 87 cases across multiple counties requiring detailed review. These involved individuals who died suddenly during police restraint. We hired 12 independent forensic pathologists to conduct blind reviews. Each case was examined by 3 separate expert panels. This rigorous process ensured objectivity and maintained the highest scientific standards. So what were the findings? The audit revealed disturbing patterns in death classifications under Dr. Fowler's leadership. In 36 of the 87 cases, expert panels unanimously disagreed with OCME. These deaths should have been classified as homicides, not undetermined, accidental, or natural. 5 additional cases showed similar problems, with 2/3 of the experts agreeing that they were mischaracterized. Combined, 41 cases demonstrate systemic misclassification of restraint-related deaths. Statistical analysis revealed significant bias in OCME's decision-making process. The data shows OCME was less likely to classify deaths as homicides. This pattern was especially pronounced when the decedent was Black. It was also pronounced when police restraint was involved. So I have to clarify what homicide means in medical examiner terminology. Classifying a death as homicide means the person died from another's actions. This classification establishes cause of death for legal and statistical purposes. However, this classification does not determine criminal culpability or mandate prosecution. Those decisions remain within prosecutorial discretion based on evidence and law. Accurate death classification is nonetheless fundamental to our justice system. Proper classification ensures families receive truthful answers about their loved ones. It enables accurate statistical tracking of in-custody deaths statewide. Most importantly, it provides the factual foundation for informed legal decisions. So moving forward. These findings demand immediate action to restore public confidence in Maryland's system. Governor Moore's executive order directs our office to take comprehensive action. We will collaborate with state's attorneys to review each audited case. Together, we will determine whether reinvestigation is warranted in these matters. The governor established the Maryland Task Force on in-custody restraint-related death investigations. This multidisciplinary task force includes state officials, legal professionals, and community advocates. The task force will identify ways to improve in-custody death investigations. It will also recommend establishing permanent statewide oversight for future cases. The executive order requires the Maryland Department of Health to review all audit recommendations. The department must ensure that OCME operates according to National Medical Examiner standards. They must also facilitate necessary training and implement policy improvements. A progress report on these reforms is required under the executive order. Let me wrap up with this. Maryland leads the nation as the first state to conduct this type of audit. We're also the first state to respond with comprehensive action. Our reforms will focus on administrative and policy improvements within existing frameworks. So I want to thank you for your attention to this critical matter. I'm prepared after Dr. Kukuka. I'm prepared to answer questions about our findings, the process, and as you will soon and quickly realize from Dr. Kukuka's presentation on the technical audit details, he is much more informed than I am. But it's a pleasure to be here and to lead this effort. Dr. Kukuka.
Thank you, AG Brown, and thank you, delegates. Good morning. Thanks for having me this morning. Thanks, Hunter. I just got that message. My name is Dr. Jeff Kukuka. I served as the case manager for the audit that AG Brown just gave you a quick overview of. I'm going to spend the next 25 some odd minutes giving you a little more detail about the impetus for the audit, the procedure of the audit, the findings of the audit, and finally the recommendations that we make in our report. As AG Brown mentioned, and as I'm sure we're all familiar, it's been about 5 years since the death of George Floyd, which was captured on a viral cell phone video. And Derek Chauvin, one of the officers responsible for restraining Mr. Floyd, was later charged with Mr. Floyd's murder. Now, at Officer Chauvin's trial, there were a number of medical experts who testified for the prosecution. That Mr. Floyd's death should have been classified as a homicide, meaning that Officer Chauvin's actions did contribute to the death. But there was one lone expert who testified for Officer Chauvin's defense, who presented a theory that Mr. Floyd's death could have been due to any number of factors, not including the restraint, and therefore the death should have been ruled undetermined. Now, as AG Brown mentioned, this was not a simple difference of opinion. This was a matter of ethics in the eyes of Dr. Fowler's medical colleagues, over 450 of whom co-authored an open letter to then Attorney General Frosch, denouncing Dr. Fowler's testimony as baseless and biased, and calling for an investigation into the OCME's practices and the appropriateness of their determinations during Dr. Fowler's tenure as chief. In that same letter, they expressed a particular concern that there may have been a tendency for Maryland's OCME to undercount homicides for deaths in police custody. That is to say, there may have been deaths that should have been certified as homicides, but were in fact certified in a different category. Soon thereafter, Attorney General Frosch agreed to co-sponsor this audit with the governor's office, and thankfully the new administration, including AG Brown, have been extremely supportive in continuing this effort. They recruited a audit design team of experts from around the world in social science, forensic medicine, and research methodology to design the audit. And we were given two main charges, one of which was, in a broad sense, to gauge the appropriateness of the determinations made by Maryland's OCME for deaths involving physical restraint, aka deaths similar to that of George Floyd, during the time that Dr. Fowler served as chief. As a secondary aim, we were also asked to design the audit in a way that would allow us to draw some inferences about the possibility that racial and or pro-police biases may have influenced OCME's determinations, which we'll refer back to just a little later. Before we proceed into any further into what we actually did, I want to make sure we're all clear on what the determinations are that we looked at. What are the determinations that are customarily made during a medical legal death investigation? Those are cause of death and manner of death. Cause of death is a purely medical determination. It is a determination of the specific injury or disease that led to the person's death. Was it a gunshot? Was it a heart attack? Was it blunt force trauma, and so forth? Manner of death, on the other hand, is not an explanation of why the person died, but rather how the person died. And as such, it is a more interpretive determination. Manner of death in Maryland is classified into one of these 5 categories that you see on the screen here. Now, because the classification or perhaps misclassification of homicides was of particular interest to this audit, I want to underscore a point that AG Brown raised a few minutes ago, which is that in the context of a death investigation, a medical context, the word homicide has a very different meaning than it does in a legal context. In a medical context, a homicide simply means that this person's death resulted, at least in part, from the actions of another person, regardless of that person's intent. So stated otherwise, a medical determination of homicide is not equivalent to a judgment of criminal culpability or liability of any kind. It just means that another human being's actions contributed to the death, or in other words, the death would not have occurred were it not for that person's actions. I want to take a moment to just credit the team that I worked with. You see on the bookends here, Tiffany Diamo and Zanita Hurley, members of the Attorney General's team who have been extremely supportive throughout this process. In the middle, you see 5 of the 6 members of the audit design team, again, experts in forensic medicine, social science, and research methodology, who very carefully and meticulously crafted and executed the procedure for this audit over a long period of time. The first task we had to complete was to identify, of course, which cases were going to be included in the audit. To that end, we're very grateful that we had the cooperation of OCME throughout this process. And one of the first things we did is we asked them to provide us with a list of all in-custody deaths that OCME investigated during Dr. Fowler's tenure as chief, of which there were over 1,300. Now, as you may know, the term in-custody death is extremely broad. It included many deaths that were outside the purview of the audit. For example, if someone were to die of a heart attack or a suicide or a diabetic episode while incarcerated, that would be considered an in-custody death insofar as they were in custody at the time. But obviously that doesn't mirror the circumstances that we were trying to evaluate here. So from that database of over 1,300 in-custody deaths, we first identified 142 cases that showed some indication that restraint may have played a role in the death, or that the decedent may have been restrained while or soon before they passed away. We then requested the complete case files for those cases from OCME, which they provided to us. They gave us everything that they had, which we could then pass along to our independent reviewers. But first, we carefully looked at those case files ourselves, and we identified 87 cases for inclusion in the audit. The criteria that we used for inclusion was that the death had to involve, it had to be a sudden or unexpected death that occurred during or soon after the application of restraint. So again, we were choosing, for lack of a more verbose explanation, the most George Floyd-like deaths in the state. Those 87 case files represented a wide range geographically across Maryland. There was at least one case from 12 of Maryland's 23 counties, as well as a plurality of cases from Baltimore City, as you can see on the map here. In terms of their distribution over time, they were fairly evenly distributed over time, about a handful of cases during each year of Dr. Fowler's tenure, apart from an unexplained spike in 2007 and dip in 2008. With respect to the characteristics of the 87 individuals who died in these cases, the overwhelming majority of them, 84 of them, were men. Approximately 3/4 of them were people of color, including 61 Black individuals and 2 Hispanic individuals. And we also looked at who was responsible for applying restraint to these individuals. In just over 3/4 of these cases, the individuals who had applied restraint were in fact police officers. In the other 19 cases, the individuals were restrained by non-police individuals. So that may include security guards, bystanders, emergency medical personnel, neighbors, friends and family, and so forth. Okay, once we identified the 87 case files that would be included in the audit, before we passed those case files along to our reviewers, we wanted to redact information that was confidential and or potentially biasing, but also irrelevant to the medical determinations. So the first thing we did is for each case file, we carefully redacted all personally identifying information pertaining to the decedent's family, as well as any OCME personnel who worked on the case. So we did not want our reviewers to know the identities of the decedent or the identities of the medical examiners who worked on this case. We redacted information such as their names, their addresses, phone numbers, social security numbers, VIN numbers, driver's license numbers, and so forth. Anything that could be considered PII was redacted. Secondly, to the extent possible, we wanted our reviewers to make these judgments without knowing the race of the individual who died. So to that end, we redacted any outright mentions of the decedent's race. You can see an example of that here, where it says the body was that of a well-developed, well-nourished, unclad, blank male. We don't know whether this individual was white, Black, or something else, and that's exactly the point. That's by design. We also redacted any physiological features that could be used to infer the person's race, such as their hair color, hairstyle, and eye color. The other thing we did with each of these case files is we obviously concealed OCME's original determinations of cause and manner of death. We didn't want our reviewers to know what OCME's opinions were so that they could form their own independent opinions. And finally, each case file consisted of obviously a large number of documents, as well as photographs of the decedent's body, as well as in some cases videos of the decedent's interactions with the individuals who were applying restraint. As I'll explain in a moment, what we did was we didn't redact those photographs, but we did delay their delivery to our case reviewers, such that their first determinations were made without knowledge of the decedent's race, and then the photos were then revealed, at which point they were given an opportunity to revise their previous determinations in light of information gleaned from the photos, if they so chose. We conducted a global search for forensic pathologists to serve as independent case reviewers for this audit. We ultimately received about 40 applications, conducted about 40 interviews, and very carefully vetted these individuals for not only their qualifications, but also for any real or perceived conflicts of interest to make sure that they were very well suited for the purposes of the audit. We ultimately hired 12 such individuals to serve as our case reviewers, 7 of whom were women, 5 of whom were men. 7 were based in the United States. The other 5 were based in other countries, namely Great Britain, Canada, and South Africa. Exactly half of the 12 case reviewers were people of color, exactly half were white, and perhaps most importantly, all 12 of them were actively practicing and highly experienced board-certified forensic pathologists themselves, with an average of about 14 years of experience in practice and a minimum of 6 years of experience. So these were very carefully vetted, very, very highly qualified individuals. Okay, this is probably the most important slide because here I'm going to walk us through the procedure of the audit chronologically. So as I mentioned a few minutes ago, there were 87 cases that we included in the audit. Every week for 11 weeks, we selected a random 8 of those 87 cases, and we distributed each of those case files to a semi-randomly selected 3 of the 12 reviewers. The only constraints on that were that each reviewer was to receive exactly 2 cases per week, no more, no less. And each case was to be assigned to at least 1 US-based and at least 1 international reviewer. So at this point, each case file has been assigned to 3 independent reviewers who were able to access and review the case file on a secure website and give their opinions about the quality of OCME's investigation, as well as, importantly, their opinions about the cause and manner of death for that particular individual. Now, at this point, during this initial survey, case reviewers had access to all of the information in the case file, everything that OCME provided to us, except for the photographs and, in some cases, videos of the decedent. So these judgments were made without knowledge of the decedent's race. After those judgments were locked in, we then revealed the photos and, in some cases, videos of the decedent to the reviewers, and we gave them an opportunity to revise their previous opinions of cause and manner of death if they so chose, again, in light of any new information that they might have gleaned from those materials. Now, as it turns out, that happened very infrequently. That only happened in about 3% of the total reviews. At this point, each case file has been independently reviewed by 3 experts. Each of those experts has independently provided their opinion of manner of death. We then intercompared those 3 opinions against each other to see if the 3 experts did or did not all agree about what the manner of death was in this case. If they were not unanimous at this point, we contacted the 3 reviewers and we scheduled and hosted an online consensus meeting where we asked the 3 reviewers assigned to that case to discuss the case with each other and to try to reach a consensus about the manner of death if possible, while also making abundantly clear that they were in no way required to reach a consensus if they couldn't. If after the final survey, the 3 case reviewers all had reached the same manner of death opinion, obviously this consensus meeting wasn't necessary. Finally, at the very last step for each individual case, we sent each individual reviewer what we called a post-consensus survey, where we revealed OCME's original determinations of cause and manner of death, which were previously hidden from the reviewers, and we gave the reviewers the opportunity to comment on whether those determinations were reasonable or not reasonable. Okay, we will now get into the results. Obviously, one of the primary points of interest was the extent to which our reviewers reached different opinions of the very same cases in comparison to the opinions that OCME had reached. So in a moment, I'm going to populate this table with numbers, and I'll highlight a few numbers that are of particular importance. But first, I just want to orient ourselves to how this table is laid out. In the rows of the table, reading from top to bottom, we have OCME's original determinations for these cases: homicide, accident, natural, and undetermined, respectively. Across the top in the columns, we have our independent reviewers' consensus or unanimous opinion of those same cases. Reading from left to right, we again have homicide, accident, natural, and undetermined. And as we'll see in a moment, a number of cases where our reviewers were not able to reach a consensus opinion. So each of these numbers reflects the number of cases that fell into each of these respective classifications. The first thing I will highlight for you is that of the 87 total audit cases, There were 13 cases, about 15%, where our 3 reviewers, even after discussing the case with each other, still were not able to reach a unanimous opinion about how this person had died. Now, perhaps not surprisingly, 11 of those 13 cases were also certified as undetermined by OCME, which suggests that these cases were either very complex, they didn't lend themselves to an obvious classification, and or the documentation available was just not adequate enough to render a firm determination. These bolded numbers across the diagonal represent cases where our reviewers reached the same opinion as OCME did. So for example, there were a total of 12 cases that our reviewers judged as, that OCME had certified as homicides. Our reviewers judged all 12 of those cases independently as homicides as well. Overall, 34.5% of the time, our reviewers agreed with OCME's original determinations. However, as A.G. Brown alluded to, there were also some alarming disagreements here. So the next numbers I'll highlight for you is the fact that of these 87 audit cases, only 12 of them were certified as homicides by OCME. But our reviewers, who reviewed those same 87 cases, unanimously judged 48 of those same cases as homicides. In other words, even though OCME and our reviewers reviewed the same cases, our reviewers judged 4 times as many of those same deaths as homicides. Now, of those 48 cases that our reviewers unanimously believed should have been classified as homicides, 12 of them actually were, the other 36 were not. So this number here directly addresses the concern raised in that open letter that I showed you a little while ago, the concern that there may have been cases that should have been classified as homicides but were not. As it turns out, it appears there were 36 cases in our sample that reviewers unanimously said, yes, this should have been a homicide, but OCME had certified as either accidental, natural, or undetermined. The next set of analyses I'll explain to you pertain to the possibility of racial and or pro-police bias in OCME's determinations. Now, how we went about looking for evidence of bias is as follows. We focused specifically on that number in the bottom left, the 48 cases that our reviewers unanimously agreed in their opinion should have been classified as homicides. And we looked to see whether the rate at which OCME actually did classify those deaths as homicides depended on the decedent's race and or on who had applied restraint to them. So with respect to the possibility of racial bias, again, if we look at the 48 cases that our reviewers unanimously agreed should have been classified as homicides, 16 of those individuals were Black, the other 16 of those individuals were white, the other 32 individuals were Black. Now, within each of these subgroups, how many of those cases did OCME actually certify as homicides? Well, if the decedent was white, they certified the death as a homicide 44% of the time. But if the decedent was Black, OCME ruled homicide only 16% of the time, which again, as A.G. Brown mentioned, is a pattern that is consistent with the possibility of racial bias, that homicides are being undercounted in general, but they're being undercounted even more dramatically if the decedent is Black. We took a similar approach to looking at the possibility of pro-police bias. Again, of those 48 consensus homicide cases, 13 involved restraint by non-police individuals, whereas 35 involved restraint by police. If we look at the cases involving non-police restraint, OCME certified 54% of those as homicides, but for cases involving police restraint, they certified only 14% as homicides. Another way in which we looked at the possibility of pro-police bias was looking at OCME's statement of cause of death. Remember, cause of death is a medical determination of the factor or factors that led to the person's death. We looked to see whether those cause of death formulations mentioned restraint as a potential contributing factor. Now, of the 19 cases that involved restraint by non-police individuals, 74% of the time, OCME said, yes, restraint may have contributed to this person's death. However, if the individual had been restrained by police, only 49% of the time did they specifically note restraint as a potential contributing factor to the death. Now, I can elaborate on this point later, but I want to be very clear about one thing before we move any further, which is that the retrospective nature of the audit from a scientific perspective prevents us from making any definitive conclusions about whether bias affected OCME's determinations. Simply put, we cannot say definitively that the differences that I just explained to you are the product of bias per se. They could reflect the influence of other relevant factors. What we can say, however, is that if bias did affect OCME's determinations, then these patterns are consistent with the patterns that we would expect to find, and statistical analyses support those inferences. Lastly, I want to touch on cause of death. We've talked exclusively about manner so far, and particularly a cause of death, an outdated term called excited or agitated delirium, which has been the subject of some controversy in recent years, and it has now been thoroughly discredited and disavowed by every major medical organization, including, as you can see here, the American Medical Association, as well as the National Association of Medical Examiners, which is the governing body of death investigation agencies. So one thing we wanted to look at specifically was the extent to which, during Dr. Fowler's tenure as chief, OCME's determinations were invoking this now discredited and rejected concept of excited delirium. As it turns out, in nearly half of the audit cases, OCME did invoke the concept of excited or agitated delirium to explain the person's death. And in nearly all of those cases, OCME certified the death as undetermined. In contrast, if we look at how our independent reviewers evaluated those same 42 cases, that is the 42 cases that OCME attributed to this now discredited concept, they judged the majority of those cases as homicides. Again, an important point of clarification here. This is obviously a point of historical interest, right? We're looking in retrospect at the extent to which OCME relied on this discredited quote unquote diagnosis and the extent to which it influenced their determinations. However, the discrepancies that we saw earlier are not solely attributable to this concept. In other words, this is not a problem. This is a problem that has been improved, but not addressed, not entirely remedied since the time frame of the audit. I'm going to skip over this in the interest of time and quickly summarize our key findings here. If we compare our reviewers' determinations against OCME's determinations for those same cases, there is clear evidence suggesting that OCME undercounted homicides during Dr. Fowler's tenure as chief, and that tendency to undercount homicides was particularly strong if the decedent was Black or if police were responsible for the restraint. With respect to this now discredited concept of excited delirium, OCME made frequent use of it, and when they did, they almost invariably certified those deaths as undetermined, but our reviewers judged most of those same cases as homicides. I'm going to conclude by giving a quick overview of the recommendations that we make in our report. There are three categories of recommendations: one for improving practices within OCME, one for improving policing practices, and one for addressing these cases that have been identified as potential misclassifications. With respect to adopting or improving OCME's practices, the first two are very straightforward. Abandon the use of excited delirium, which again is a now thoroughly discredited and disavowed concept. We recently learned that OCME has indeed abandoned the use of that term since the time frame of the audit. The other thing we recommend, which again is very straightforward, is that OCME needs to adhere more closely to national generally accepted standards for death certification that are propagated by the National Association of Medical Examiners, namely what's called the but-for principle for classifying homicides. The but-for principle, which I alluded to earlier, means that if another person's actions contributed to the death, regardless of that person's intent, that death should, according to that standard, always be classified as a homicide, but it is not a judgment of criminal culpability. With respect to OCME's procedures, a number of our reviewers noted that there was a lack or an inadequacy of autopsy photographs, so we encourage more and better, more thorough documentation of the autopsy, particularly in these complex deaths, and that OCME remain up to date on the most current scientific understanding of the physiological effects of restraint, particularly prone weighted restraint, so that we can be confident that their determinations are based on the most current scientific knowledge. Our reviewers in some cases noted unexplained variation in how OCME handled different cases. And for that reason, we call for more standardization of procedures. In other words, cases shouldn't be handled in wildly different ways without explanation as to why those approaches are different. And finally, we call for more expanded quality control measures, including, for example, external peer reviews of OCME's work to ensure that they are adhering to at least some minimum standard of quality. With respect to policing, one of the most common things that our reviewers lamented is that the case files could have used more information about the restraint. How long was the decedent restrained? What was their body position? What was their behavior? How many people were restraining him? And so on and so forth. Now, one way to go about doing this, of course, would be to obtain more verbal accounts from individuals who were witnesses to the restraint. Ideally, not individuals who were involved in the restraint, but individuals who were bystanders to it, who for various reasons are likely to provide more comprehensive and more objective accounts. But speaking of objectivity, an even better way to transmit information to the medical examiner's office about the nature of the restraint would be through the use of camera footage, whether through body-worn cameras, surveillance cameras, dash cameras, anything that gives the medical examiner a complete and unbiased record of what exactly occurred during the incident. With respect to the training that police officers receive, it's obviously important that they be trained in appropriate restraint techniques. That is to say, restraint techniques that are non-lethal, that are not likely to be unsafe, and that are developed in conjunction with medical experts who can testify to their safety. But it would be even better if the use of restraint weren't necessary in the first place, if we could de-escalate the situation to a point where the use of force isn't needed. And to that end, we recommend involving mental health experts, social workers, and the like in responses to individuals in crisis. Perhaps not surprisingly, many of the individuals who died in these cases were either experiencing severe mental illness and or under the influence of drugs or alcohol at the time. We believe it would be helpful to involve individuals in crisis response teams who have specialized expertise in working with individuals in crisis and can help hopefully to de-escalate those situations. Finally, with respect to those cases that we identified as potential misclassifications, cases that ostensibly should have been classified as homicides but were not, we have recommended to the Attorney General's office that those cases should be re-examined to determine whether any further action is warranted. Again, to be clear, this is not a judgment of criminal liability. This is simply saying these cases should be looked at again to determine whether there might be further action that is necessary. We also hope that other states obviously will follow suit using our audit procedure as a blueprint, conducting audits of their own. We have very little reason to believe that all of the issues that I've raised here today are unique to Maryland. In fact, historically, OCME has been one of the more reliable agencies in the U.S. And there's plenty of reason to believe that these issues are systemic and not unique to our state. We also called for a 5-year follow-up audit in Maryland to gauge the extent to which these recommendations have been helpful in terms of improving OCME's practices. As I'm sure you're well aware, this is just sort of scratching the surface. We have published a 70-page report that gives a lot more detail about our motivations and procedure and findings and conclusions and the like. And I encourage you to check that out. I'll be happy to drop the link in the chat should you like to have a look at that. Anyway, with that, we still have a solid 20 minutes for questions. I thank you again for your attention, and I already see a number of folks with their hands raised. So, Mr. Chair, if you'd be happy to.
Yes, we'll start to call. There are quite a few questions that are coming from the committee, and so I'm going to start working my way down the list here. We'll begin with Delegate Kaufman, then we're going to go to the Vice Chair, then Delegate Erican, and then I'll continue. Delegate Kaufman, please.
Yes, thank you, Mr. Chair. Can you hear me? I have two brief questions. And then they're for the Attorney General, but you may defer to Dr. Kakaka for sure. I'm trying to understand as a non-lawyer about why the hesitancy to classify so many deaths as homicides without getting into Dr. Fowler's head. Is there greater exposure for a defendant potentially if a death is classified as a homicide, or do you have any theories as to why the hesitation occurred? And my second question is, I appreciate the work of the task force and Dr. Kakaka's amazing work, but in my experience, many task forces and audits collect dust. So what are you and he going to do to ensure that that his work is not one of those instances, that it actually makes meaningful changes that restore the trust of the Office of the Chief Medical Examiner? Thank you, Mr. Chair.
Mr. Attorney General.
I'll be brief. I think one of the beauties of this audit is we didn't look at motive. We didn't look at theories of hesitation because that's a lot of speculation, and we're not in the head of Dr. Fowler or any medical examiner in the office. We looked at the facts, right? That's what the team looked at. They looked at the data, the facts, independently arrived at a determination, then later, as Dr. Cook mentioned, compared it to what the original determination made and present the evidence for your consideration, for the public's consideration. So we intentionally stayed away from things like motivation, hesitation, speculation, etc. In terms of gathering dust, look, the governor is committed to this, as I know the General Assembly is interested in this issue. The task force that he established, he gave them very clear, specific charge and guidance, coming back with regular reporting on progress. Two of the three recommendations for OCME and Department of Health, recommendations for law enforcement and training, direct guidance to my office to work with state's attorneys into the cases that were identified as in need of review. So there's a real sense of urgency and clear guidance in the executive order. I think you'll see that this is not something that will just sit on the shelf.
Thank you, Mr. Chair.
Thank
The
you.
only thing I briefly add is I just want to make clear it is not, nor has it ever been our intention to denigrate the work of Dr. Fowler or his colleagues. What we're revealing here are systemic issues, and we don't get in the business, as AG Brown said, about speculating about motives or intent or anything of that nature.
Thank you for that. We'll go now to the Vice Chair, who may have to be off her camera for a moment, but we'll go to the Vice Chair, then Delegates Erican and Phillips.
Thank you, Mr. Chair. My question, I have one for Mr. Attorney General and one for the doctor. My question for the Attorney General is, in reviewing the edict of the task force, I noticed that there wasn't mentioning with the task force, there wasn't a mention with respect to what is going to happen for the families. So, for instance, as it stands now, legislation says if a family goes through the appeal process, it gets changed to homicide or undetermined from suicide and natural, then that family can keep that the investigation stays open for 20 years. my question is, not having that trigger here, because this was not at the impetus of the family, this was at the impetus of the audit. Do you need legislation to say, now the family can do, these cases will stay open for 20 years? So, or can these families survive that without having to go through that process, and just go ahead and have these cases open for 20 years for investigation purposes?
So, Iverson, thank you for that question. We've been very mindful of, attentive to, sensitive to the needs of the family. The briefing that you received today, they all received it and or were invited to receive it. Some of them did not want to, and we understand that as well. So certainly by legislation, you could do what you suggest. There's no doubt about that. There are some who have asked the question, could OCME sort of sua sponte on their own go back and take a look? That's also a possibility. Not something that I could direct. So you've got the legislature obviously could take action. OCME could take action as well.
I'm going to jump in quickly with the follow-up question, though, that goes to further investigation, I guess, of those cases that would have been found to be homicides in the context they died because of another person's actions. I guess I'd go to Dr. Kakaka, who may be able to give me an answer, or well, we'll find out. How many of those cases happened prior to the time when the General Assembly gave the Attorney General the ability to prosecute police-involved deaths?
Chairman, I can answer that because you gave us the authority in October of 2023. So the entire universe that was reviewed predates that. Let me say, though, because I think the sort of the core of your question may very well be who has the authority to do the investigation, and only if and only if the facts would lead to a prosecution, and that's a big if. Right? There's no criminal culpability that's being suggested here. Would the Attorney General have the authority to prosecute? Would that be something that a state's attorney would do? Clearly, the state's attorney who in the jurisdiction would have that authority, and the Office of the Attorney General. Keep in mind, the IID is one a body or entity that you know of in the OAG that does criminal investigation prosecutions in law enforcement involved. In these cases, and again, if and only if, big capital, all bold, if there was evidence that suggested prosecution, the Attorney General has the authority to investigate homicides. And so the authority is there, and I'm emphasizing the authority. I'm not suggesting anything whatsoever. We are going to sit down with state's attorneys. We're already in that discussion with them. They've received this briefing. We briefed state's attorneys before we release the report. We're going to work closely with them and review the file, beyond the OCME file, to look at police reports and see where that leads. And then in terms of the authority, we have the authority to investigate because the governor put that in the executive order. And then in terms of what happens next, we will work with state's attorneys to make that determination.
Mr. Attorney General, I guess the other question would be, would the independent investigator, would the IIU investigate? I mean, it's gone through an audit process. It's been carefully looked at. I understand you're talking to state's attorney's offices too. Is there a role for the IIU in this process for determining whether or not the case should be prosecuted?
Not under the authority of the 2021 and the 2023 legislation, but the OAG has the authority under its more broader authority for criminal investigations and prosecutions.
All right. Thank you very much for that. I'm getting a couple text messages from members of the committee because I've only been listing 3 members at a time. It's because many of you have your hands up. So I'm just trying to direct traffic here a little bit, and I hope you'll all bear with me.
Mr.
The next
Chair,
30, yes, Madam Vice Chair.
I apologize, but I did have 2 questions.
You had a second question?
Yes, and
all right. Well, I apologize. Let's go to your second question.
That's okay. My second question is quick, and this is for the doctor. I wanted to understand the 5-year repeat of an audit. Why that time frame as opposed to a 3 or 2, given the nature of some of the biases that you found, or that the group found?
Yes, ma'am, that's a great question. And we discussed this on page 55 of our report. So if you want information, I would direct you there. But the short answer is we're not wedded to 5 years as a hard and fast time period. We just chose 5 years because that was a length of time that we estimated there would be enough data by that point to conduct a comprehensive audit. After 2 or 3 years, there may simply not be enough cases to draw firm conclusions.
Okay. Thank you to the Vice Chair. We'll go now Delegate Arikan, then Phillips, then Taylor.
Thank you, Mr. Chair. Thank you for being here, Dr. Kakuka. I just have a couple questions about the study protocol. I was looking on page 22 and it says that like how you were choosing the reviewers, and it said that you removed some people for obviously personal relationships with the doctor, being from OCME, obviously ethics violations, but you also have in here controversial media coverage. Could you define that?
So for this question, I actually was not personally involved in the interviewing process for the reviewers, so I would defer to, I don't know if Zanita or Tiffany are able to comment on this.
Let's have Tiffany, who's one of the deputy attorneys general. She's on. Tiffany, do you want to handle that? Zanita, do you want to handle that?
Sure. And I don't think I can turn on my own video. Can you all hear me?
Yes.
Yes. So we wanted to protect the integrity of the audit. And so we did run applicants' names through open data to see if there were any comments associated that could be attributed to reviewers that would undermine the perception of their ability to independently review these cases. And so that is what the term, any controversial media would apply to.
Okay, so like what terms did you guys search for?
We just ran their names through and then we looked at their mentions in the media. And so if there were any statements that could be attributed to the reviewers that suggested their alignment with a particular philosophy, for example, or belief that would suggest that it would be difficult for them to independently review these types of cases, then, we might consider that disqualifying.
And how many people would you
We're
say?
not talking about political beliefs or ideology. The classic example, did this examiner, when they witnessed Dr. Fowler's testimony, go to social media and say outrageous, or did someone go to social media and say this is a problem across America and we've got to look at it, that type of thing? Did they have public statements that would have undermined, from a fairly objective standpoint, the credibility of their participation on the audit design team?
Okay, that's very helpful. Thank you. And then my other question about the audit design was, I noticed during the consensus meetings, there was special attention paid to protecting the reviewers' anonymity. What would the scientific basis be for keeping the reviewers anonymous to the public?
There's a number of reasons. I mean, some of the reviewers plainly feared professional repercussions if their participation in the audit was made public. So we sort of reassured them throughout the process that, they could remain as anonymous or as non-anonymous as they felt comfortable with. The other thing I can say from a scientific research perspective is, in effect, the reviewers were participants in a research study here, and it's standard protocol to keep participants' identities anonymous for confidentiality reasons. So none of this is really out of step with standard protocol. We did give them the opportunity to make their identities known, but ultimately all of them declined.
Okay, and Mr. Attorney General, do you find that that may become problematic during prosecution if the defense wants to cross-examine people who maybe, for example, they hadn't come to an agreement, they were forced into this consensus meeting, the outcome became different? I'm just picturing a situation where defense counsel might actually want to cross-examine some of these people. And since there was no recordings, it says here, of these meetings, we don't even know what occurred during these meetings. Do you anticipate any potential problems there?
So we could literally have a full committee hearing on sort of, issues around, criminal cases, civil cases, and liability. I'm just going to answer it very briefly. We've assessed both, kind of criminal, when I say, issues that come up in the context of a criminal case, as well as a civil liability. And we assess 0 to no, to little risk of that.
Okay. All right. Thank you very much.
Thank you. We'll hear now from questions from Delegate Phillips, then Taylor, then Sample Hughes.
Thank you, Mr. Chair. And I didn't have this question originally, but now I do, based on Attorney General, your comment. One question that I have, and I'll start with this, is if the OAG reviewed a matter that was not, given everything that we know today, that was not ruled as a homicide, would you still have the authority to review that matter of an in-custody death if the OCME did not rule it as a homicide?
Let me maybe answer it this way. I don't know if it's, the 36 that were identified originally or determined originally to be undetermined, that were later determined by our independent auditors as homicide. That's our focus.
So, but would you, so under the current kind of legislative authority, if OCME does not rule something as a homicide, you still have the ability to take a look at that and potentially to even prosecute. So you would actually be overruling their decision, so to speak.
Wow.
I'm just trying to be clear on that.
Let me be clear as well that the audit teams
and I'm not just talking about this audit. I'm not just talking about this audit. I'm just talking about in general.
The reason why I'm going into this way, neither the audit team's determination nor any future review actually changes the official determination. The official determination is still undetermined. I do not have authority. I didn't through the audit team, and I don't under any other authority have to review determinations by the OCME for the purposes of changing those determinations. I don't have that authority, and I never did.
And so you would not be able to prosecute unless something was determined to be a homicide.
No, that's not accurate.
And that's what I was trying to get to.
Okay. I think if you talk to prosecutors, and, prosecutors, automatic dockets, a lot of volume, they're looking at a variety of pieces of evidence during the preparation, the investigation of a matter. And the OCME determination is often determinative in their decision, and you'll hear a prosecutor that will say, if I have an homicide determination versus an undetermined, I'm more likely to look at the one that's determined as homicide and not likely to one where there's a undetermined determinate manner of death.
So it does impact that. Second question on death certificate updates and corrective actions. Has OCME been working with you on making any, and you said there was a recommendation that they go back and look at this, but have they done any of this voluntarily, just based on everything that's taken place? And has anything changed from, because you went through 2019, what happens with the last 5 years?
Oh, other than the comment that Dr. Kukuka made that we know that they have abandoned the excited delirium, I think it was as of 2023, 2024. I really can't speak to what OCME and the Maryland Department of Health has done or intends to do. But as part of this kind of moving forward effort, we will be working with them, both as a partner, and we've got attorneys that advise them as well.
Well, you made some recommendations. In your opinion, as a former legislator, are there some of your recommendations that should be codified from a legislative perspective?
I was careful in my opening remarks, and I did say that I believe the recommendations can be done in the existing sort of framework, administrative regulatory policy framework. I think the OCME oriented recommendations can be made at OCME without legislation. The police reforms, the same. Does that mean that you can't do legislation? You certainly could. And if you intend to do that, we certainly would want to participate in that legislative effort. Nor do we need legislation for the recommendations to the Attorney General to review the cases. So none of the recommendations require legislation. They all could be done by legislation. And if you're going that path, we respectfully ask that we be involved to help shape that.
And my last question, Mr. Chair, because I know I've got a lot of questions, is just transparency and public access to OCME data. My sense is that most of this stuff happens in a very closed environment. Is there any thoughts that you have on creating more transparency behind the way OCME reports things out?
Look, and as you probably know, there's no secret there have been, PIA lawsuits taken against OCME for what they disclose in connection with their autopsies and the supporting material and the like. Transparency is important. They understand that. There is some data in the possession of OCME during the course of their work that is protected from disclosure. Some mandatory conceal, if you will. So that's a hard question, and that's probably also a subject of a full-length bill hearing or hearing, I should say.
Okay, thank you, Mr. AG.
Thank you, Delegate Phillips. We'll go to Delegate Taylor, then Sample Hughes, Simmons, Grammer, and Embry. And at the moment, that may be where we have to bring this in for a landing. But Delegate Taylor, please.
Thank you, Mr. Chair. I think my question can be answered fairly quickly. Has to do with the task force. Really interested in knowing sort of what the makeup is of this task force. When the report is due. I don't know if we got any details there. And then my second question has to do with the parameters around police custody. Like, really, what does that mean? When are you really in police custody? Is it through, when you're detained at the site, you're in the car? Does it also include being placed in the detention center? Is that also part of police custody? And, that's really part of my big question is, how many of these 36 deaths that were deemed homicide by the audit actually occurred in a detention center?
Let me get, I'm going to answer. I'm going to turn it over to Dr. Kukuka. And also, in the meantime, if Tiffany and/or Zanita could put a link to the executive order in the chat, that would be helpful. And you'll see that. And if we can't get in the chat, we'll certainly send it to you. Custody is different than restraint. And there's a whole body of case law as to when somebody is in police custody. And again, that's a subject of a 2-hour legal briefing on what custody means. And all the things that you mentioned could very well constitute custody under certain conditions. That's different from restraint. And I'm going to turn it over to Dr. Kukuka to put a finer point on the restraint.
Yeah, AG Brown's absolutely correct. I mean, the legal concept of custody becomes very complicated very quickly. There's also a psychological component to feeling as if one is in custody, even if one is not legally. So that's why, we focused on cases where individuals were unequivocally being restrained that may have been physically through the use of force, handcuffs, shackles, weight, and so forth. It could have been electrical in nature, aka the use of a taser. It could have been chemical in nature. So some sort of injection to sort of subdue the individual. So those sort of the broader definition of restraint. All of these cases involved at least one of those forms of restraint. And to answer your latter question, only one of the 87 deaths actually occurred in a detention center.
Okay. All right. Thank you. We'll go to Delegate Sample Hughes now.
Thank you, Mr. Chair, and good afternoon, actually morning to all present. I wanted to ask you 2 questions. with regards to the recommendations of the potential external controls, or at least having external review, is there a prescribed frequency that is to happen? Because I'm asking from the standpoint of, when these reports had occurred, was there ever any internal quality controls and other experts that were there to be able to weigh in and look at the writings and the writings and the technical reporting, as well as the photography, because that was in that on the document as well for page 44 that talked about that it wasn't of good quality and things like that. I was curious, does that even happen at the beginning of this process at all, or within it, prior to trying to secure and bring in your external experts? That's my first question, and then I'll get to the second one after that.
Sure. I'll try to be brief. There was evidence of what I'll call internal review in the form of case conferences, where OCME staff would discuss the case with each other. It would obviously ultimately be reviewed by the chief, Dr. Fowler, who would sign off on the adequacy of the investigation and the examination. So that I guess you could call it a safeguard. That safeguard was in place. However, a lot of the problems that we found evidence of are evidence of non-adherence to broader standards of the field. So that's where we see the potential benefit of having periodic external reviews to make sure that, for example, OCME is adhering to national guidelines and national standards. We do not, as I recall, prescribe a particular frequency with which those reviews need to be conducted. We do, however, suggest that those reviews are likely to be more valuable for certain types of cases. One of the sentiments commonly expressed by our reviewers, in fairness to OCME, is that many of these cases were very complicated. And would have been of the sort that would have especially benefited from a second independent set of eyes on the information. So we're open to OCME taking different approaches there. I could certainly see, for feasibility purposes, taking a triage approach where they apply those external reviews to the cases that are most complicated, most problematic, most with the strongest potential for bias and so forth.
Okay, thank you. And then the second part, this is more of a on the scene question. Just recently, actually in Greensboro, just recently last week, this week actually, due to traffic and the transport company couldn't get there to pick up the decedent, and so the decedent was still in the actual vicinity of where the unattended death occurred. But my question is, at what point, say, when the police was there to, address the issue, and they ended up needing, it's what I've been told, to move the decedent without the medical examiner there or the investigator there at that given moment, does the police have the responsibility of taking pictures prior to any movement and just looking at the overall case? What is their responsibility?
That is an excellent question that goes beyond my expertise. Does anyone else want to chime in?
Well, I don't want to have it. It may vary from jurisdiction to jurisdiction in terms of what law enforcement's responsibilities and duties are, either by their department's SOPs, state law, etc. When you think about, though, the recommendations that Dr. Kukuka and the audit design team, Dr. Kukuka presented, the audit design team recommended, photographs are important, right? Photographs and videos are important. We know that when law enforcement responds to a crime scene, evidence collection, right? Securing, controlling a crime scene, evidence collection. I mean, these are all important. There are protocol standards that are in place. So I think that's probably the best answer we could give you at this time.
Okay, sure. I was just basing that comment on the report overall conversation of things that have happened on the onset and things that didn't happen during the investigation of the cases in particular. And so I was just curious where that brings law enforcement involved. So thank you very much. Thank you, Mr. Chair.
Thank you. Delegate Simmons now, then Grammer, then Embry.
Thank you, Mr. Chair, and thank you, AG Brown. And just want to ask you, pertaining to the staffing of the medical examiner's office, Was that a consideration around the investigation of capabilities of the medical examiner office when we look at some of these faults that took place? Are we looking at the staffing and qualifications of the medical examiners, as well as the funding to that agency, far as to make sure they had the overall capabilities to mitigate these investigations of deaths that are taking place throughout our state?
I defer to Dr. Kukuka and Zanita Hurley on that one.
Again, it's an interesting question. You know, I don't think it's our place to comment on the adequacy of the staffing or the funding. I mean, that's not something we looked at in the same way that we didn't look at their motives. You know, I will tell you there were we were very intentional, as for obvious reasons, to not identify by name any of the OCME staff who were involved in these cases, because it's not our intent to draw attention to them or to denigrate them. But I can tell you that these ostensibly misclassified cases were not limited to a small number of individuals. This appears to be a product of the prevailing practices that were in place at the agency at the time.
Thank you.
All right. Go to Delegate Grammer, then Delegate Embry.
Thank you, Mr. Chair. I think I have three brief questions. The first is about the definition of homicide. The definition of homicide that we heard on here today is a little bit different than the one in the report. It sounds as if a person contributes to the death of another in any small way, that is a homicide. Can someone clarify or correct me?
So the official.
Before Dr. Kukuka speaks, let me just say this. You know, we've given an oral presentation today, and certainly any oral comments that may have defined or characterized or stated something that has a legal term or definition, we rely on the authority for that definition. Homicide is defined in statute, and homicide, there is a standard definition within the field of pathology on what a homicide is. So whatever discrepancies or confusion, the confusion attribute to us, but certainly we are not in this briefing defining any of that. We're doing our level best, though, to convey what they are. So having said that, Dr. Kukuka.
Yeah, no, thank you, Delegate. It is a sticky concept, so you're right to ask for clarification. In our report, I assume you're already here, but I would direct you to the third bullet point on page 14, which is an excerpt from the official guide for manner of death classification that is published by the National Association of Medical Examiners. That is the authoritative definition of homicide from a death investigation standpoint. And the standard that death investigators are required to follow is that if a person's death would not have occurred but for, meaning were it not for the actions of another individual, regardless of their intent, then it should be classified as a homicide. So I can give you a quick example from their manual. You know, if, for example, there is a hunting accident where an individual fires a gun aiming at an animal, misses the animal, hits another human, that death is a homicide, even though they had absolutely no intent to kill that other person, because that other person would not have died were it not for their actions. So the act needs to be, there's a subtle distinction here. The act needs to be volitional, meaning it was done on purpose, but it is not required to have intended to cause harm. That is the distinction in the standard.
That's a perfect segue to my second question. So how does the Office of the Chief Medical Examiner differentiate between an accident and a homicide in the cases where a person is acting to protocol, they're within their authorities and responsibilities? I put, via the protocol, I put the restraint on properly, but that contributed to the death of a person. Where's the actual difference here? Because it could be actually accidental, but a person dies and now you're subject to felony murder or if it's negligence, maybe manslaughter. So what's the actual practical difference in terms of the Office of the Chief Medical Examiner?
Yeah. No, that again, a terrific question, because it is murky. There is a level of judgment involved, and as our audit results show, it is not at all uncommon for different examiners to have different thresholds for where an accident becomes a homicide, which is of course concerning, right? If you have multiple experts looking at the same case and arriving at different interpretations, and interpretations that I don't have to tell you all have very far-reaching consequences.
Okay, and that is a perfect segue to my third and final question. So it was mentioned, and I read through the report that there were some safeguards so that some screening processes for the actual cases where they would scan for racial or pro-police biases. Was there anything built into the case review or the selection of the reviewers to deal with bias? So you could pick any two people from this committee and have them select the participants of this review, and you'd likely have a radical different pool of people. These people, from what I've read in the report, were selected by the Office of the Attorney General, who has strong opinions. Were there any safeguards for either the cases or the selection of reviewers for an anti-police bias?
Again, I wasn't involved in the vetting process proper. So with respect to the sort of personal views of the reviewers, those would have been addressed during those interviews, like we mentioned earlier. Zanita, I'm not sure if you wanted to speak to that more.
I would respond by saying that, as we looked for any controversial statements or that could be attributed to the reviewers, they would include pro-police, anti-police, anything that could suggest that the reviewer would be inclined to find a pro-police or racial bias or the reverse. So we really did, and obviously looking at publicly available data, we also included in our interview questions whether they were aware of anything in their past that would undermine their ability to participate in the audit and be fair in assessing the cases. So we did, put into our review process a strategy for trying to avoid anyone who was biased in either direction. And in establishing a 3-person review panel, we also sought to ensure diversity in terms of U.S. reviewers, international reviewers. We sought racial diversity, gender diversity of reviewers. So we did seek diversity and to try to exclude anyone who had any bias that could undermine the audit results.
Well, I did review the interview questions, and I'm asking this because I didn't see anything in regard to this specifically. While, in the report, it shows redactions of things that may lead to a racial bias or a pro-police bias, but I don't see, for example, something if a person had strong feelings about the criminal justice system, if they had a negative experience with a law enforcement officer, things to protect against that. So I guess the root of the question is we've kind of built in this whole thing is about subjectivity. And we've built in some things to deal with bias where a person may be to root out racial bias or pro-police bias. But I don't see anything in either the selection of the candidates or the review of the cases to deal with, for example, a person who might have very strong feelings about the criminal justice system, where on the opposite side, I see specific things in the report that would root out maybe a pro-police position. Can you comment on that?
I'll take that. We did not conduct, let's say, voir dire like you'd have in a jury, right? We did the things that Ms. Hurley mentioned. I think the thing that that is probably most significant in addressing the potential for bias, whether it's race or attitudes towards police, are the controls that we put into the review themselves, which Dr. Kukuka explained, the redactions of information, the composition of the 3 panel reviewers and how we randomly selected them and made sure we had the right balance. Then the later disclosure of the pictures that then did show race and an insignificant departure from the original determinations. So while it may not be perfect, it certainly meets, I think, what the peer reviewers in this field of research would say are more than adequate and reasonable controls for bias.
Thank you, Mr. Chair.
Thank you. Delegate Embry.
Thank you so much, Attorney General and Chair and Dr. Kukuka, for everything. I just wanted to circle back to the ongoing peer review, because I think that's one of your most important recommendations, because I think that could be used to mitigate bias. And I know that traditionally peer review means reviewing everything, including the conclusion of the initial medical examiner. So I just wonder if you have recommendations or might work with the OCME to be very intentional about what that peer review looks like, so that you're limiting the potential for bias on an ongoing basis. And thank you.
No, thank you for that question, because I couldn't agree more. I mean, peer review is, peer review is only beneficial to the extent that it's structured in a scientifically appropriate way. So it would be my pleasure to make sure that that is indeed the case. We also allude in our report to the possibility that those peer reviews could be race blind as well, to limit the potential for racial bias in those reviews as well. And I would go one step further as to say that those independent reviews should also be blind to OCME's original determinations, so that those determinations are truly independent. I mean, anybody who's ever had to get a second opinion from a doctor or a mechanic knows that peer review becomes pretty useless if you shoot yourself in the foot right off the bat by telling the reviewer what opinion they're being asked to corroborate.
Thank you.
All right. I want to thank the Attorney General, Ms. Hurley, Dr. Kukuka, and everyone who's been part of this today. I think it was a very helpful briefing where we were able to gather a lot of information on this very, very important issue. And I'm sure it is something that we will come back to either in the months immediately prior to the General Assembly session or during the first couple of weeks of the General Assembly session. So we'll be hearing from you more again. If anyone has any further questions regarding this, they can forward them, anyone on the committee can forward them to Hunter Marsh, and we'll be sure to give those to the Attorney General. But for now, this has been the House